Welcome everyone to this webinar hosted by 5 St Andrews Hill. Thank you very much for attending today. You will be hearing from 3 of us today. We're talking about Interpol and the Extradition Act, and new challenges and opportunities that can be raised since we formally exited the EU. You'll hear from Ben Keith and Amy Woolfson and myself. At the close or at the end of the talk, we will have a question and answer session, and you should see a question and answer button at the bottom of the screen. You can put in any questions there and we will endeavour to answer them. Ben is going to deal with the question of what an Interpol is and how it works. So I will hand over to you, Ben.
Thanks, Louisa. I see people are still joining. Hang on, my screen decided to freeze. So what I was going to discuss very briefly is just give you a quick outline of what Interpol is and its purpose, and then we're going to go on to deal with some of the other topics, namely its constitution and some of the recent developments in Interpol practice. Interpol itself is, as some of you will know and some of you are unsure about, an international police cooperation organisation. They are not a police force with officers stationed around the globe. They are not, as the movies, who have agents ready to arrest people. They are really a post box for international cooperation. They are a conduit by which different national central bureaus, so different agencies from around the world, can cooperate and communicate together effectively in joint operations and in the pursuit of illicit finance and criminal people accused or convicted of criminal offences, as well as helping locate children and other problems with human trafficking. There's 194 member states of Interpol, and it's run by the General Secretariat. The General Secretariat is run by a man called Jürgen Stock, who's a German lawyer who's been in charge for quite a long time. The General Secretariat administers the whole of Interpol. Below or above them is the General Assembly, which is a bit like the United Nations. So every state has its own representative and it has its own vote at a General Assembly. There was meant to be a General Assembly just before Christmas to elect a new president, but that hasn't taken place. The office of the presidency can be a bit controversial in that the most recent president but one, Meng Honwei, was in fact disappeared in China and then reappeared a few months later, admitting to bribery offences. So Interpol has a slightly checkered history sometimes in terms of its membership, a bit like the United Nations. It tries its best, but given that everybody is a member, most people are a member of it, it can have a lot of problems. Its purpose is, for the purposes for today's talk, essentially is to the location and assistance in extradition proceedings in order to find individuals who are wanted or convicted of criminal offences. They do that by the form of a red notice usually, and we're going to talk a bit later about how you might go about removing a red notice and how those red notices are going to impact upon the United Kingdom in the near future in the post-Brexit scenario. They are a data processing organisation, and so the rules which govern them and allow you to challenge issues with Interpol and to discuss issues with Interpol are essentially based on data protection, quite technical legal language. And the challenges that you can make to Interpol red notices and to other notices and the submissions that you can make are detailed essentially in Interpol's constitution. I'm not going to go take you through all the articles. Amy is going to give us a brief synopsis of sort of some of the key elements of Interpol's constitution and how it operates.
Thank you, Ben. In terms of Interpol's constitution and what is it, I would define it a little bit wider than just the actual constitution document itself. I would include what they call the Statute on the Commission for the Control of Files. That's the organisation or the part of Interpol which actually processes requests and deals with, importantly, requests for deletion. And then you also have the resolutions of its General Assembly and the rules on the processing of data. In terms of the Constitution, Article 2.1 and 3 are the most important. 2.1 states that the purpose of Interpol is to ensure and promote the widest possible mutual assistance between criminal police authorities within the limits of the law and in the spirit of the Universal Declaration on Human Rights. And its references to those limits of the law and also the Universal Declaration on Human Rights that can present a bit of a way into challenging red notices. And then Article 3, which states that it's strictly forbidden for Interpol to undertake any intervention or activities of a political, military, religious or racial character. And again, that's another way in, which I know Louisa is going to expand on. The CCF, that's the Commission for the Control of Files, and also Interpol itself, are bound by the rules on the processing of data. And again, that's a useful port of call if you're seeking to challenge a notice, because they set out what the purpose of a red notice is, and also the minimum requirements for issuing one. So, for example, where a person is wanted for prosecution, it must be for an offence that carries at least a 2-year sentence of imprisonment. In terms of the statute for the Commission of the Control of Files, that really sets out the formalities for making a request for deletion. Finally, I would refer to, again, what I say is the kind of wider concept of Interpol's constitution, which are the resolutions of its General Assembly. And there are a series of important resolutions about what they call the predominance test, which could be said to really broaden the scope of Article 3, so that it's not just that you can object on the basis that a request is of a political, military, religious or racial character, but also that it's one where it's a predominantly of that character. The one thing that I would add within all of this is that Interpol is essentially a supranational body. It's not accountable to any other court. It's really only accountable to itself. So you do have to work within Interpol's own rules and language in order to try to dislodge these things. I'm going to hand over to Louisa now, who's going to say a few words about the increased role of Interpol now that we've left the European arrest warrant framework.
Thank you, Amy. We have, as I'm sure many of you are aware, lost our access to the Schengen Information System, SIS2. That was a database which sent out alerts to police and border guards, and it had been a vital component to our national security. It has over 90 million alerts from 31 countries. And in 2020, there had been more than 600 million checks made by the UK authorities. We lost access to that system when we formally exited the EU on the 1st of January. And you'll no doubt have been aware from some of the press reports that during the Brexit negotiations phase, the UK was very keen to maintain access to that system. What it's meant is that the UK police now have or have had to switch to Interpol and the Red Notice system for international extradition requests from Europe or in Europe. That has left a significant gap in our capability to secure our borders, and there is a risk of us becoming a safe haven for fugitives. That's because alerts now have to go through this system. It doesn't have the sophisticated, the Interpol system, which doesn't have the sophisticated functionality of SIS2. This was highlighted relatively recently. There was a House of Lords Select Committee on the European Union. The Security and Justice Subcommittee met on the 26th of January of this year and considered issues relating to security since Brexit. That committee heard from individuals including Steve Rodhouse, the Director General of Operations for the NCA, as well as the Assistant Chief Constable Peter Ayling. And they both highlighted that the reason for the problem is that the police and border guards have lost real-time access to receive alerts about wanted or missing people. Interpol Red Notices, unlike alerts on SIS2, are not automated, so entries must be uploaded manually once officers decide whether the information warrants being circulated. Assistant Chief Constable Peter Ayling said that, said as follows, there is work ongoing to design concepts that might improve that visibility and access in the future. That is work that we're closely engaged with the Home Office on under the International Law Enforcement Alert Platform, ILEAP. It is very early stages and it's difficult to comment, but that would be about increasing the functionality of the Interpol system of notices to make it more readily accessible for UK policing. There's work in place that would hope to optimise that arrangement. The Interpol system isn't connected to the police national computer. Steve Rodhouse addressed the issue of a comparison between the functionality of SIS2 and the Interpol system, which is labelled as I-24/7. He highlighted that what's been lost is access to information in operational scenarios on the street. So, for example, stop and search and traffic stops, etc. He said that the challenge for us is to make sure that officers, officers using the gateway through the PNC still have access to the data that's available to us, i.e. the NCA. Albeit it has to be through the Interpol system. The route for making that jump between I-24/7 and frontline officers is typically through the UK's International Crime Bureau, which is operated at the NCA. So when I-24/7 or Interpol notice alerts arrive in the UK, we now have a process to put them on the police national computer in a relatively short time, which is a number of hours, he says, as opposed to a number of days. He said he was confident that there is going to be a reduction in the gap in timeliness and data in that respect, but he highlighted that there are caveats, and that is because it requires EU member states to create an Interpol notice rather than simply circulating a request on SIS2. And there is, of course, nothing to force an EU country to do that. So the consequence is that there's a decline in the numbers of extradition requests from Europe, and that's something that I'm sure we've all no doubt noticed. And it does remain to be seen whether there will be an increase in the numbers of those requests in the future, particularly as there is improvements adopted in relation to the Interpol system. But certainly at the moment, there is a delay in those requests being made and being accessed by frontline officers. I'll stop there because also relevant in this context is the question of, or the issue of provisional arrests, and Amy is going to deal with that topic.
Thanks, Louisa. So the Extradition Provisional Arrest Act, I'm going to briefly outline the new power of arrest in that Act, and then explain how it's an example of Interpol gaining a greater role in our extradition processes. Because in short, for the first time in the UK now, a person can be arrested without a warrant based on information contained in a red notice. So the Extradition Provisional Arrest Act received royal assent in October 2020, and it is now in force. It's not so much a freestanding act as a series of amendments to the Extradition Act 2003, and specifically, it inserts new section 74 capital A to 74 capital E into the Extradition Act. And in doing so, it creates a power of arrest without a warrant for extradition requests from certain trusted Category 2 territories. And those territories are, firstly, our Five Eyes partner countries. So that's the US, Australia, Canada, and New Zealand. Plus also Switzerland, Liechtenstein, Iceland and Norway. For all other Category 2 territories, the position remains that a requested person can only be arrested on a warrant issued by a judge in this country. So that would either be a warrant following a full request certified by the Secretary of State, or a provisional request under Section 73 of the Extradition Act. So if you have, for example, a person wanted by India, the position remains that they can only be arrested on a warrant. Where things change is where somebody is wanted by the US or one of those other countries on the trusted Category 2 territory list. So why have we got this new power of warrantless arrest? It was said that there was a gap in police capability whereby the authorities might be aware that a person wanted by a Category 2 territory was in the UK, but that there was no judicial warrant to enable their arrest. So, for example, if the police encountered somebody by chance, the difficulty with that is there's still a process of certification that has to be conducted by the NCA. It was argued that a request can be certified by the NCA faster than a provisional application could be made to a judge. That was certainly what was argued. Interestingly, the impact assessment published with the bill estimated that based on the current list of countries, over a 10-year period, only 6 people would enter the criminal justice system sooner than they would otherwise. There was no specific case cited where this power would have made a difference between somebody being arrested and somebody not being arrested and potentially getting away. So in its own right, arguably this seems to be a pretty thin basis for legislating. Now, at the time that the bill was introduced, which was January of last year, our future extradition arrangements with the EU 27 were still in the balance. So arguably, there was a measure at the time of putting in place a fallback position, but obviously that fallback has now been dealt with through the Trade and Cooperation Agreement. So the new Act brings the position for trusted Category 2 territories a lot closer to the position for Category 1 territories. As I say, there's this process of the NCA certifying a request. If a person is then arrested without a warrant under the new power, they must be brought to court as soon as is reasonably practicable. And the judge has to consider whether, if the person hadn't already been brought before them, would they have issued a provisional warrant for their arrest. If not, then they must discharge them. But if they find that they would have issued one, then the process will start as if that person had been provisionally arrested. And they can be remanded for 45 days or 65 in the case of the US, pending a full request. As I mentioned, there's an increased reliance on Interpol Red Notices in the process here. The government guidance confirms that the Red Notice is the means by which the request is communicated by the trusted Category 2 territory. And so this new power of arrest has really been grafted on to the existing Red Notice system. And the Red Notice system wasn't designed for that. As we know, Red Notices mean very different things to different countries. I think it's interesting that the US itself doesn't actually consider a Red Notice to be on its own a sufficient basis to arrest somebody. It says that it doesn't meet the probable cause requirement in the 4th Amendment to the US Constitution. And instead, the US would treat a UK Red Notice simply as the basis to be on the lookout for somebody and to notify the authorities if they found where they were located. So arguably, this is opening up a potential new imbalance in our extradition arrangements with the United States. What's the practical effect of this new power? Well, you've heard the potential impact of these 6 people coming into the criminal justice system. It does seem a bit unlikely that the NCA are going to start going back through all the Red Notices issued by these countries and certifying requests back to the year dot, just on the off chance that these people might be in the UK. Arguably, it's going to be a lot more intelligence-led. But the bigger question, in my view, is, well, where are we going with this power? It seems inevitable that further countries will be added at some point to this list of trusted territories. you can envisage this being a negotiating tool or something for diplomatic relations, it being quite an attractive thing to be used. And further countries can be added to the list through secondary legislation. So potentially what this really is a wedge to move through far more category 2 territories into the scope of warrantless arrest. And as that happens, concerns about the quality of those arrests, the quality of the underlying Interpol information, and the respect that countries have both for human rights and also for the integrity of Interpol is going to multiply and no doubt come under challenge in the UK. I know that Louisa and Ben are now going to talk about ways of challenging the red notices themselves.
Thank you, Amy. I was going to deal with one of the main ways of removing an Interpol red notice, which is through showing that it's a politically motivated request. Interpol's constitution prohibits Interpol any requests of a political character, but that's slightly different from a political motivation. So firstly, in order to remove an Interpol red notice, you need to make an application to the Commission for the Control of Files, or the CCF, setting out your submissions as to why an Interpol red notice has been issued politically, and attaching various documents. Interpol in recent times have changed their format to include a form, and also to reduce the number of pages you're allowed to produce. You're only allowed to send them 10 pages of submissions, which cuts down quite a lot of legal work. But you can also include a bundle of information, essentially cross-referencing what you're saying in your submissions. And it's worth here just having a discussion about the difference between political opinion and political motivation. For those of you who read the Julian Assange judgment, DJ Beraitser actually dealt quite nicely, although people might not agree with her, or at least dealt with one interpretation of what political offence means. And political offence essentially is about the character of the offence itself. So, for instance, a political offence might be incitement to riot. It might be electoral fraud. It might be, for instance, abuse of power by Yulia Tymoshenko in the Ukraine, or a request for Viktor Yanukovych, which dealt with, again, with abuse of power when he was a politician. And those offences are fairly easy to show that they're intrinsically political by their nature. But those are actually very few and far between. The offences that somebody is accused of are, by their nature, political. More common are offences which are politically motivated, but are of a general character. So most corporate raiding cases or politically motivated prosecutions usually are for fraud-related offences. So they usually involve an allegation against an individual of some sort of large-scale fraud or a regulatory offence, for instance, failure to pay national insurance for your employees, failure to pay a particular type of tax, be it VAT, sales tax, or the like. And these can be extremely complicated allegations against clients. But behind those allegations is either a politician or political power that wants to take over somebody's company or put somebody out of business. Or straightforwardly, an allegation which is designed to leverage somebody into giving evidence against another politician. And in order to show that, to show those, when you've got a fraud allegation, for instance, or sometimes even I've seen murder used as a criminal offence to accuse somebody, you've got to show more of the background. You've got to show that the person involved, well, one of the ways to do it is to show that the person involved or your client is a politician or has political sympathies or interacts with politicians. So often people who are the subject of red notices or abusive political red notices might not be politicians in and of themselves, but they might have had dealings with politicians. They might be in business with those politicians. And showing that usually through media reports. If it's not possible to show through media reports, then I will often provide a relevant short expert opinion from an independent expert to try and show that there is a political hand behind the allegations, and make your submissions to Interpol, and then Interpol will examine the case. But then Interpol don't take your word for what you say. Usually, they will then usually go back to the country that has made the extradition request or the Interpol Red Notice request and ask them for more information or to confirm that this is of not political character. A lot of the time, countries don't respond, and then Interpol remove the red notice, and sometimes they do. And usually when they respond, they say, no, this is definitely a real fraud charge against a real person for fraud. It's nothing to do with politics. So by way of an example, one red notice I remember was a politician who was a former head of oil and gas for a CIS state, and he had been present in a meeting where gas and oil assets had been sold to the wrong state and undervalue, and an extradition request, an Interpol Red Notice was issued for him. We defeated the extradition request, and then you have to go through the process of asking Interpol to remove the extradition request, because what they actually wanted him for was to give evidence against a former politician, rather than for an actual criminal offence. Interpol have helpfully provided a series of sort of ideal cases on their website, which I think Lucy is going to deal with in more detail. But a couple of examples that pertain, for instance, to political cases are those Interpol Red Notices that are issued during the course of arbitration or civil proceedings. So I recently represented an individual who was engaged in major fraud litigation, international fraud litigation in three jurisdictions. And during the course of that litigation, his opponent, who is a political actor, had sufficient funds and clout to get the Prosecutor General's office to issue a prosecution against him. This caused untold problems, for instance, with World Check and rescinded World Check, which meant that he didn't have access to his bank accounts. It caused huge problems in terms of the litigation. And the idea of that was, of course, to then go to the courts in different jurisdictions and say, well, hang on, the opponent is in fact wanted for a criminal offence. And through a combination of quite hard work through different groups of lawyers and us in the UK and some other lawyers overseas, we were able to get Interpol to remove that notice and showing that, in fact, because the nature of the dispute, the civil dispute, was fundamentally political, and the individuals involved fundamentally political, that they could remove the red notice. I mean, a more obvious one is one that Amy and I did last year involving a Kazakhstan case where an individual was requested for a fraud offence from Kazakhstan, and we were able to show that, in fact, he was a former human rights defender who had been quite vociferous in his attacks on the Kazakhstani government. And Interpol, in fact, removed that red notice with very little to do. There are other issues. So when you make the applications, it's heard by the CCF, who are I think 7 of them, the sitting committee. I've had cases where one or two, where the Russian member stepped out of the committee because he'd issued the red notice for my client, who he said was political. But there's no appeal mechanism from them, as Amy said earlier on, that they are a supranational. They have immunity from suit in France. And although some imaginative lawyers have tried to take them to court in France, so far nothing has happened. So if the CCF say no, that's not quite the end of the day. You can go back with further information, a bit like a renewed bail application in the UK, to put it in simple terms, where you have significant further information that shows that in fact you were right all along. And in some cases, I have had to go back 2 or 3 times as the case develops, because you say it's politically motivated, but sometimes it takes quite a lot of time to gather that evidence effectively. And as time goes on, also the other side will often reveal their hand and show more of the political motivation that is going on behind the scenes. But it's really a fast marshalling of evidence that's the most important part of that, because often my clients will come to me and say, well, actually, I'm in the UK and I want to travel, and I want to travel quickly. I'm only in the UK for a few days. I was only in here for a few days. And to show political motivation for somebody who's not super high profile takes time and energy. And you have to have the right, and sometimes if you're not able to do that, then you have to find a good expert who can give you a short report. You can send to Interpol and say, look, here is a world-renowned expert who says that these people who are involved in this particular battle are political actors, and you should be really worried about the political motivation behind this prosecution, not just about the red notice. A large number of my red notices obviously come from former Soviet states, but there are also serious issues with Interpol red notices from Middle East, particularly the UAE. There have been some publicity about Qatar as well. They are, I think Louise is going to deal with this a bit more. They're less overtly political to show, but because of the power structures in a lot of those countries, particularly in Abu Dhabi and Dubai, because the power structures, if you fall out with somebody who's a part of the royal household or the royal court, then whilst not political per se, that will subject you to serious allegations of criminal misdeed and then result in Interpol red notice, which can really stop, particularly if you're in international business, can really stop you in your tracks, because you can't travel. As it sets off the money laundering checks and can cause you all sorts of trouble going forward. That's a very sort of brief run through in how you go about sort of showing that an Interpol red notice is politically motivated and make an application. But that's not the only way in which you can remove a red notice. And Louise is going to deal with other ways in which you can argue that a red notice could be removed.
Thanks, Ben. So that's right. You can request for the removal of a red notice for non-political reasons. You're requesting the deletion of data, so you need to refer to the rules, and that's the rules on processing of data, to explain what violations have occurred. Because consideration must also be given to the to whether the red notice complies with the aims under the Constitution. Amy set out before the principles under Articles 2 and 3, and you'll have heard that there's an emphasis on human rights. And because of that constitutional emphasis on human rights, challenges can be brought in the following context. So you've got the violation of the right not to be discriminated against under Article 2 of the UN Declaration of Human Rights, right to liberty or life, liberty and security under Article 3, right to be protected from torture and inhumane and degrading treatment, Article 5, right to an effective remedy under Article 8, not to be subjected to arbitrary arrest, detention or exile, Article 9, fair trial rights, Article 10, right to a fair hearing in accordance with the law, Article 11. And you can cross-reference against your extradition experience and knowledge. So if, for example, the UK has refused to extradite to a country on the grounds of human rights abuses, or perhaps in the context of prison conditions, then that's how you focus your challenge, and you can use that knowledge and experience to formulate your challenges in this context as well. So, like with extradition challenges, the use of case law and expert reports is relevant. To bring red notice challenges, you need to consider the rules on processing of data. So under Article 83, it sets out the minimum criteria. One of those is that the offence concerned must be a serious ordinary law crime. And it specifies underneath that red notices may not be published for the following categories of offences. Offences that in various countries raise controversial issues relating to behaviour or cultural norms, offences relating to family or private matters, offences originating from the violation of laws or regulations of administrative nature or deriving from private disputes. And then there's a penalty threshold, which I think Amy referred to before. So there's at least 2 years for a prosecution matter and at least 6 months for a conviction matter. So, for example, considering those criteria, I challenged a red notice issued from the UAE for failing to honour checks. So a bounce check case, many of you may be familiar with those sorts of matters. Not a criminal offence here unless there's dishonest misappropriation shown. So there was a basis to bring a challenge to the red notice on the basis that if the UAE were to make an extradition request to the UK authorities, the executing court would have to determine under Section 78 of the Extradition Act whether the offence specified in the request is an extradition offence. And so there's reference there to the dual criminality requirements under Section 138. And obviously you've got the comparable sections with regards to European cases. Challenges can be made where the allegation appears to be no more than a civil dispute. Sometimes it's not altogether clear on the facts, where the applicant, for example, says one thing and then information received from the relevant country says the opposite. And in those sorts of situations, Interpol isn't going to engage in that sort of a dispute. So you'll need to demonstrate quite clearly the information and basis upon which you say that it's just simply a civil dispute and it's not just based upon an account from your individual client. Interpol won't necessarily be persuaded where there's an agreement between parties in the context of civil proceedings. So you'll see examples on the Interpol website. There's a case, one of the last 3 cited on the Interpol site, where the Commission was presented with a formal settlement between the applicant and the alleged victim company, who had made a complaint to the relevant country, giving rise to the criminal allegations. So you had a document demonstrating that formal settlement. The applicant put it within his application to Interpol, and the Commission said that settlement had indicated was set out in terms that didn't admit any liability. So they scrutinised the terms in which the agreement was made. And doesn't indicate, they said, why a certain sum of money had been transferred to an applicant in the circumstances of that case. They went on to say that the Commission could not conclude, as suggested by the applicant, that this constituted a clear demonstration that the data would be inaccurate. So you'll need to analyse the quality of any documentation that you have in order to assess whether it can be used to mount a challenge to say that the conduct is not criminal or that it simply relates to a civil dispute and nothing more. Article 83 1A doesn't require Interpol to conduct any sort of detailed assessment into the credibility of the allegations, but a challenge can be made against the publication if it can be shown that the allegation is without any evidential basis. You'll also need to look at sentencing. So Amy touched upon this, as I said before. You can bring a challenge where the sentence requirements aren't satisfied. So, for example, in the case I mentioned before, the bounce check case, there was a maximum sentence of a fine where the value of the checks fell below a certain amount. And so a challenge was brought to say that threshold had not been reached when considering certain repayments which had been made. And so information was provided to demonstrate what the threshold was, the repayments it had made, and then a challenge was brought in that regard. The other requirement is that there must also be an arrest warrant issued, and so that is another basis that you need to look at when considering challenges against the publication of a red notice. that is a whistle-stop tour of some of the challenges that you can make that are non-political, and I'll now hand over to Amy to tell you about recent developments on how the courts have viewed red notices.
Thank you, Louisa. I'm going to be talking about a recent Advocate General's opinion from the Court of Justice of the EU, which touched upon Interpol, specifically in relation to data protection and also double jeopardy. Personally, data protection is something that I'm very interested in relation to Interpol. And Ben and I have actually got an article coming out about this case very shortly. I'm also going to tell you a little bit about an Interpol case that Ben and I advised on, where data protection was a live issue. So the case that the Advocate General gave his opinion in is the case of WS and the Republic of Germany. The facts of that case were that WS was a German businessman who had got caught up in some allegations of corruption and bribery in Latin America. They had come to the attention of the German authorities, and they'd been dealt with by way of effectively an out-of-court disposal. That wasn't the end of it, though, for WS, because the US authorities began to investigate and then issued a red notice for WS. WS argued that this was double jeopardy because the matter had been disposed of already in Germany. And the German authorities, the German law enforcement, essentially agreed with him and agreed that he should not be arrested on the red notice in Germany. WS then argued that, well, it's a restriction on his freedom of movement in the Schengen area, because if he left Germany, he would be liable to arrest on this red notice. The German court, in my view, had some sympathy with that, and they referred a number of questions to the CJEU. The Advocate General said, well, on the facts, it's not clear that double jeopardy did apply because there wasn't a finding of a court in Germany, that the matter wasn't disposed of by a court. It was done really with law enforcement and the prosecutors. However, what the Advocate General said is that where there was a judicial finding of double jeopardy in a Schengen member state, then the person shouldn't be arrested on a red notice within the rest of the Schengen area. And the Advocate General noted that the purpose of a red notice isn't simply to arrest a person, but could also be to locate that person and then notify the requesting state. It is interesting that this was a US request, because you can compare and contrast that now to the position in the UK, where if WS were here, in theory, he could be arrested without a warrant, pursuant to a certificate issued by the NCA, using that new power of provisional arrest, which I've already described. As so often happened with these references to the CJEU, the most interesting question really went unanswered, and that was the question about what the lawful basis was for sharing data with Interpol. It's clear that the German court was very interested in the question. As Ben's explained, Interpol is a supranational organisation. They might be based in France, but they're not subject to French law. As an international organisation, specific rules direct how data can be shared with them under the EU's law enforcement directive. And the law enforcement directive provides that data must not be transferred to a third country, so that's a country outside of the law enforcement directive, or an international organisation, unless there's either, firstly, an adequacy decision from the EU Commission, or that there are appropriate safeguards, including a legally binding instrument and a risk assessment, or that there are exceptional circumstances, such as an immediate threat to public security. In this case, it would have appeared that there was no adequacy decision, no appropriate safeguards, and no exceptional circumstances. So why were they sharing data with Interpol at all in these kind of cases, other than because they always had done? As I say, the Advocate General ruled the question inadmissible, but I suspect it's not going to go away. In the UK, well, we're no longer part of the law enforcement directive, but the equivalent provisions are contained in domestic law in Part 3 of the Data Protection Act 2018. So the question arises again, what is the lawful basis for the UK sharing data with Interpol? Furthermore, as Interpol has been described to yourselves, it's a clearinghouse really for data and a bridge between law enforcement in one jurisdiction and law enforcement in another jurisdiction to share law enforcement data. So what is the lawful basis for the NCA sharing law enforcement data outside of the countries that are party to the law enforcement directive? It's not just an academic question, and it becomes particularly pertinent where a red notice is contested. As I say, Ben and I worked on a case where a red notice was deleted. It was a red notice obtained by a country outside of the EU. And having been deleted, it appears that the NCA remained in control of the data and also then continued to share information with the requesting country about this person, even after the red notice was deleted. And therefore, we challenge the lawful basis on which that was taking place. It's hard to see what the basis can be, and we would anticipate future challenges on it. As I say, we do have an article coming out on this quite soon. I think Ben's now going to talk about some developments in the US.
Well, actually, what I was going to say is that there's been a recent success or judgment in the United States in the Circuit Court. Fair Trials published the article. Fair Trials International intervened in that case, and that dealt with the US court looking at the status of a red notice in immigration proceedings. So whether the fact that somebody had a red notice against them or was subject to red notice meant that they were necessarily accused of or convicted of a serious non-political crime and therefore excluded under the Refugee Convention from refugee protection. And the Fair Trials International intervened in that case, and the US court in fact found that the red notice wasn't enough to show that somebody was accused or convicted of a serious political crime because it didn't pass the probable cause test. That's quite, although we haven't got similar in this country, it's quite a useful authority. I think that only came out a couple of weeks ago, because it's rare that we get to see any immigration authorities which deal with red notices, because they usually just deal with the extradition request themselves. So that's a good indication that in fact UK, that we could use that in immigration proceedings or asylum proceedings to show that in fact UK, when somebody is accused or subject to red notice, you're not necessarily excluded from the Refugee Convention, which is quite important, particularly for people who are claiming asylum pending the expected issuance of an extradition request or pending some sort of criminal prosecution taking place in their country of origin. So in fact, we've had two. We had we haven't yet had the judgment from the Advocate General, from the Court of Justice of the European Union. We only had the Advocate General's opinion so far, but they tend to follow the Advocate General's opinion. So there's been two recent decisions in courts about red notices, which we hope will sort of start to build some jurisprudence and help individuals not just challenge, but sort of understand what they're all about. I was now going to we're going to take some questions. So if you've got any questions, please type them in the Q&A box, and then we will try and divide them up and answer them. I've got one. Well, Ed Grange has got a question in very early, and his question was, how is an arrest on a red notice issued by a country with which we have extradition arrangements any different than provisional arrest on a provisional warrant issued through diplomatic note? And why could this be seen as more abusive? So, in my opinion, well, the difference really is that the provisional arrest warrant strictly has to have a judicial oversight, albeit only a justice of the peace, which is somewhat terrifying in the Extradition Act. It has to go to a judge or justice of the peace in order for a warrant to be issued, whereas under the new provisions, you could just issue the red notice, have somebody arrested, and then, but without any judicial oversight until they get to court. And of course, as we know, once you get to court, it's then much more difficult to challenge, particularly if all you've got is a 2-page red notice, which all it's got is your name, your nationality, a photograph, and one line of what the offence is. You know, Ben Keith is accused of fraud in Russia is not something that's very easy to challenge when you make a bail application in Westminster Magistrates Court or anywhere else, for that matter. So I think that's really the issue. Plus, at the moment, and it's coming back to me at the moment, are only very few countries that have signed up to that provisional arrest warrant power. There is a statutory instrument in place that hasn't yet been enacted, which essentially includes all of the EU 27 and other countries in it. So we would effectively be in it was partly, we think, because of the potential of certifying everything as Part 2 on the 1st of January because of Brexit. But there was a scenario envisaged where everybody could be arrested just on a red notice without any judicial oversight at all. I mean, Ed's point is how often are provisional arrest warrants refused? The answer is I don't know that. And we probably won't. We'll probably never will. But I think anything that lessens the already low judicial oversight over some of these processes is potentially problematic, particularly if we include a lot more countries. So we've got another question, which is, hang on, I'm just two more questions back. So one question is interested to know our thoughts on the wider implications for counter-terrorism efforts as a result of the loss of access to the Schengen information system. Louisa, I think I'm going to direct that one to you.
Yeah, it's certainly. I mean, I mentioned before the subcommittee, the House of Lords subcommittee, and it was one of the issues that was raised. I mean, I think it's wider than just the loss of the Schengen information system, because we've lost access to other information sharing databases, and that was certainly flagged up as a problem. And I think it was pointed out in somewhere within the report on that had the Paris terrorist attacks happened now rather than when we were a member of SIS and these other information sharing databases, we wouldn't have been able to respond with the speed with which we had at the time, because there wasn't the possibility or availability of data to intervene at the borders and put systems in place immediately. And I think it was pointed out that Interpol wouldn't have enabled that instant response to be adopted, whereas under the SIS system, the other information sharing databases, it would have done. So I mean, on the basis of that and some of the other criticisms highlighted in that at that committee meeting, it seems that there is a serious concern about counter-terrorism efforts being able to respond quickly and adequately to an immediate threat. So I hope that sort of answers the question. I can see some other questions are cropping up. Ben, do you want to sort of deal with any other matters or highlight any other issues?
There's one. I think there's one more question we can take, which is I think unless Amy wants to deal with it.
The question was about diffusions. In terms of the provisional arrest, the government guidance anticipates a diffusion also being a basis for potential certification by the NCA. So, I mean, in theory, the NCA might look at a diffusion and filter it out at that stage. I guess the answer is that we don't know. In terms of safeguards on actually obtaining or securing a diffusion, there's no internal change in Interpol. It's simply the UK response to that information being shared with us.
I think it's also worth saying that the diffusions are pretty not controversial, but they have come in for a lot of criticism over the years because they are more open to abuse than a red notice, because you can just, the old system was that you could just upload a diffusion from your National Census Bureau and it would just be sent out without any proper checks. And Turkey, in particularly after the attempted coup, uploaded thousands and thousands of diffusions with allegations of essentially people being Gulenists for no good reason. And Interpol eventually sort of waded their way through them and took quite a lot of them down. But that system hasn't been stopped, so it's still around, and it would still be open to abuse. So, but we don't. I know Fair Trials keep campaigning for better oversight of diffusions, but the fact is that Interpol just don't have the capacity to really examine diffusion notices properly when they're uploaded, until usually defence lawyers draw them to somebody's attention or prosecution lawyers draw them to somebody's attention. We're just coming to the end now, but Louisa, have you got anything? Do you want to wrap up for us?
I will wrap up. There is, I believe, a recording that's going to be available of this webinar, should you want to relive this interesting experience. And I just want to say thank you to everyone for giving up your time this afternoon and for attending this webinar. We're very grateful. So thank you on behalf of 5 St Andrews Hill, and goodbye.